So you've probably heard that on Friday, the Supreme Court ruled largely in favour of the finance companies, meaning millions of motorists would not be able to claim any compensation against their lender for discretionary commission arrangements. But some people may still be able to claim, and there is a consultation going to be launched by the Financial Conduct Authority, which will address any compensation due to be paid out. So hopefully in this video, a concise explanation as to what all that means. And I say hopefully because normally when I say that, the video is about 15 to 20 minutes long, but please do subscribe all the same. Let's take a look first of all at what the FCA describes a discretionary commission arrangement, which they banned in 2021 because they felt they were somewhat unfair. In simple terms, when you sit down with a dealer to arrange finance on a vehicle, they act as the credit broker and the lender lends you the money on the vehicle. Now, a discretionary commission arrangement was where the credit broker within the dealership, often the dealer itself or a separate credit broker who sat within the dealership, would negotiate that deal with you and was able to change various bits of it, including, for example, the interest rate and the amount of commission received or any other financial consideration payable to the credit broker, whether directly or indirectly, changed depending on the bit that they were allowed to change by the lender. That made it a discretionary commission arrangement. In other words, if they sold you a deal that had a higher level of interest and they received higher commission for it, that made it a discretionary commission arrangement. Now, as I say, these were banned in 2021 for being somewhat unfair, but that didn't stop several conjoined cases going to court, which ultimately ended up at the Court of Appeal last year, which was then appealed to the Supreme Court, which released its ruling on Friday. So let's take a look at what was being claimed and what the Supreme Court ruled as against what the Court of Appeal ruled. Now, largely, the argument here was that the credit broker should have what we call a fiduciary duty, that is, a duty to act in your best interests, and therefore that these commission payments amounted to some kind of bribery, whereby they got a higher amount of interest, they got more money. Now, the Court of Appeal said that the car dealers were breaking the law if they got paid these commissions by lenders without telling you in full and getting your full permission. And of course, this would have applied to almost all car finance deals before 2021 that applied such arrangements, because these arrangements were very common. And of course, that meant that many millions of customers would be able to claim compensation, which meant the whole cost of the thing would be in the region of £44 billion. The Court of Appeal, as I mentioned, decided that they broke the law, but the Supreme Court had a different view. They said, well, in fact, these dealers don't have a fiduciary duty to the customer. They are acting in its business best interests and not in your best interests. But it didn't end there. It did take one case where it said that this arrangement was unfair. The relationship between them was unfair. And thus that one claim succeeded, which means some people may still be due a payout. So let's take a look at a couple of snippets from the Supreme Court ruling as to what happened and why. Now, as the Supreme Court says here at paragraph 4, these appeals arise from proceedings brought by 3 customers who obtained used cars from 4 dealers under hire purchase agreements involving 2 lenders. And it describes each of the transactions in more detail, but in each case, there was either no disclosure of the existence of the commission or only the disclosure that a commission of an unidentified amount might be paid. That's where it says we might be paid a commission on this deal. They each claimed an amount equivalent to the commissions from the lenders under the tort of bribery. Obviously, if they had a fiduciary duty to act in your best interest, but they got a higher payment because they got a better rate or something like that, that was claimed to be the tort of bribery, hence it was wrong, so they claimed. The Supreme Court disagreed and said that they don't have that fiduciary duty. However, the size of the commission was very important, because in this one case that was successful, the Supreme Court said as follows: the commission paid by First Rand to the trade centre, so that was by the lender to the dealer, was £1,650. So that was the commission amount. Now, the Supreme Court said, now this must be compared with the total amount payable by Mr. Johnson, the individual who was successful, under the credit agreement. The credit agreement was £9,422. So in comparison, that amount would have been 17.5%. The advance of credit was £6,399, which was a comparison of 26%, but the total charge for credit was the big one that made this stand out, so that comprised of the interest and the fees, etc., of £3,023, meaning the commission payment of £1,650 was 55% of the overall charge for credit, which the Supreme Court felt made that relationship unfair. And in fact, further down, one of the bits that stood out here was that Mr. Johnson had said that if I'd been told the overwhelming majority of the cost of this agreement to me was just a commission payment to the dealer, I simply would have walked away and gone to a different dealership. The Supreme Court also said that the existence of the commercial tie between the dealer and the lender and its non-disclosure to Mr. Johnson is a further consideration highly material to the issue of unfairness of the relationship between them. Despite the fact that Mr. Johnson was provided with several documents, the Supreme Court noted that neither the suitability document nor any other document provided to him disclosed the existence of this tie, and therefore the Supreme Court agreed with the Court of Appeal on this point that the omission of a key fact was a suppression of the truth. And so in its overall conclusion, the Supreme Court said that because the dealers present were not subject to a fiduciary duty towards their customers, it follows that the customer's claims against the lenders in equity, or fairness, and in bribery cannot succeed. So the lender's appeals in these cases, so far as it was based on bribery or on equity, are therefore allowed, meaning the lenders won. But the one win for consumers is where the Supreme Court did rule on an unfair relationship arrangement with the customer, whereby that connection or the commission amount was not fully disclosed. The Supreme Court said the relationship between them was unfair within the meaning of Section 140A of the Consumer Credit Act, by reason and in particular of the size of the commission, the failure to disclose the commission, and the concealment of the commercial tie between the dealer and the lender. Mr. Johnson was therefore entitled to succeed on his claim on that basis. However, the order made in his favour by the Court of Appeal was vitiated by mistakes, and therefore technically the Supreme Court allowed the lender's appeal only to substitute it with an order in Mr. Johnson's favour on different terms than those made by the Court of Appeal. In other words, Mr. Johnson did win, but on slightly different terms. So this does mean that many people will still be able to claim in cases where the commission, either there was an arrangement that was not disclosed or the amount of the commission was sufficiently large so as to result in an unfair relationship. They say the scheme should cover agreements dating back to 2007. They say they'll focus on high commission arrangements or undisclosed commission arrangements, which might make the arrangement unfair. In this particular case, as I mentioned, it was 55% of the total cost of the credit, as a powerful indication of an unfair relationship. Their current advice is that people who have already complained don't need to do anything else. Their advice remains that consumers concerned that they were not told about commissions or think they might have paid too much for the commission should complain now. They say they aim to make the scheme easy to participate in without the need to use any claims management company, they say, because they might claim up to 30% in fees. But of course, if you want them to do it for you, you can choose to do that. They are just saying they're going to make it easy so you don't have to have anything deducted from your ultimate compensation payout. So I hope you found that relatively concise and useful. I'll drop those links in the description below. Please do subscribe to the channel. And as always, thank you for watching.